Okay, hello, welcome back. This is video number 6 in a series that I'm doing on the Fair Debt Collection Practices Act. This is not legal advice, this is for educational purposes only. It is your responsibility to learn the law and to know the law. A little bit of wisdom here. If somebody knows how to read, yet they never ever read anything, then they are basically illiterate, and their reading does them absolutely no good. Same thing with the law. If there's a law and nobody ever uses it, then it's a useless law. So that's why we want to learn the law. We want to learn how to put the law, use the law to our advantage, and that's what we're going to try to do here. So on with this video. 1692E, false or misleading representations. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Number 1. The false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge, uniform, or facsimile thereof. So if they say or imply in any way that they're affiliated with any government agency, with any state agency, with a police agency or police force, or any sort of or some sort of a legal company or something like that, it's a violation. The false representation of A. the character, amount, or legal status of any debt, or B. any services rendered or compensation which may be lawfully received by any debt collector for the collection of a debt. So there's a couple different things here. The legal status of a debt, they might try to tell you, a lot of times these charged-off debts, a charged-off debt is basically uncollectible because the original creditor got a credit with the IRS for tax purposes. So that the legal status, if they say that that's a fully collectible debt, then there may be a big question there. It's probably a violation. And then another thing that they do, if they tack on any sort of charges or something like that, then they're looking for trouble, big time violation. Number 3, the false representation or implication that any individual is an attorney or that any communication is from an attorney. So they like to do this a lot, is say that they're attorneys because they believe that this puts people, and with good reason, it scares people, and they think that they're going to get a lawsuit because this guy's an attorney. But if they're not an attorney, well, guess what? It's a big time violation. Number 4, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person or the seizure, garnishment, attachment, or sale of any property or wages of any person unless such action is lawful and the debt collector or creditor intends to take such action. Now, here's something. If they represent or imply that non-payment is going to get you arrested, which it should never do, or imprisoned, that just doesn't happen. There is some cases where people have gone to jail associated with debt, but it was not because of the debt. It was because they were in violation of a court order regarding the debt, and so they went to jail for contempt of court, but not because of the debt. And if they say that they're going to garnish or attach wages or something like that, well, if they're not bonded in the state that you live in, then they really can't do that. So that's violation. They have to be bonded in the state in order to and have license in the state in order to conduct business in the state. The threat to take any action that cannot legally be taken or that is not intended to be taken. So if they rarely take any action, but then they threaten that they're going to, it's a violation. 6. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause the consumer to A. lose any claim or defense to payment of the debt, or B. become subject to any practice prohibited by this title. Okay, so if they make some kind of a representation or imply in any way that if they do something along the lines of a sale or referral, that you're going to lose some of your rights, especially if you're going to lose your rights under this Title 15, then big time violation. You can sue them for $1,000 to $3,000 for that, or for every time that they make that claim. So if you're husband and wife, $1,000 for each of you. 7. The false representation or implication that the consumer committed any crime or other conduct in order to disgrace the consumer. Now this comes under harassment, abuse. If they're telling you that you're some sort of a criminal because of this debt, this uncollected debt, in a lot of cases it may have absolutely nothing to do with you. But they're wanting to say that you're a criminal or something like that. Big time violation. Number 8, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. So this is threatening to ruin your credit rating, to destroy your credit. One thing they do a lot, once a debt is disputed, and has to be written, documented dispute, you need to send them a letter in order to do that. But then once that's sent in, they need to report to the credit bureaus every month that is disputed. And if they don't, and it's something they rarely do, then that's a violation. And if it's disputed and they don't show that monthly, for every month that it's not disputed, it's a $1,000 violation, and you can just let that add up and up and up. Number 9. The use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by any court, official, or agency of the United States or any state, or which creates a false impression as to its source, authorization, or approval. So if they have any documentation that simulates or looks like it is some sort of official government state-issued communication, big-time violation. 10. The use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information concerning a consumer. So any sort of false representation about who they are, they could call up and have all kinds of different stories about locating a consumer or some sort of a emergency or something like that. When you have them in that sort of a situation, big time violation. It's good to have the caller identification on your phone, or be able to go online and find out when something like that happens who that caller is. 11. The failure to disclose in the initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, in that initial oral communication, that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose. And the failure to disclose in subsequent communications that the communication is from a debt collector, except that this paragraph shall not apply to a formal pleading made in connection with a legal action. Okay, so they are bound to disclose in any communication, in the initial communication and in following communications, that they are a debt collector, and that any information obtained will be used for that purpose. The only exception, as stated here, is a legal pleading, which would be if there was a lawsuit, and in the law papers it does not need to be disclosed that they're a debt collector. It's kind of taken for granted at that point. Number 12. The false representation or implication that accounts have been turned over to innocent purchasers for value. Now this would be an idea that they might come up with that would try to make you feel guilty, or make you feel like you were a criminal, or try to get that you were trying to get away with something. They never sell these sort of things, these accounts, to innocent purchasers, for one thing, and they never sell them for value. They sell them for pennies on the dollar. They're charged off accounts. They literally pennies on the dollar, and then they try to squeeze people to send the money in. 13. The false representation or implication that documents are a legal process. If they send any sort of documents to you, and then they try to tell you that they're a legal process, that's violation. If they send documents that look like they are legal documents, like legal pleadings, and they are not, that is a violation, especially if they never intend to file a lawsuit. The use of any business, company, or organization name other than the true name of the debt collector's business, company, or organization. Once again, this is some deceptive kind of business that they're trying to say they're somebody that they're not. Maybe they're going to try, again, they might be trying to use some sort of state agency, a law agency, or something like that to try to scare somebody into sending in a payment. Number 15. The false representation or implication that documents are not legal process forms or do not require action by the consumer. Now here again, this is the other side of number 13 up above. If they send you a document that does require some sort of a legal process or a legal answer, for instance, the initial letter that they send to you, you have 30 days to file a dispute with them, and you can still file a dispute after the 30 days, but if they try to tell you that you don't need to do anything and it turns out that you did, big time violation. Number 16, the false representation or implication that a debt collector operates or is employed by a consumer reporting agency as defined by Section 603F of this Act. That would be a credit bureau, credit reporting agency, and if they tell you that they work for a credit bureau or a credit reporting agency and they don't, big time violation. Anyway, that concludes this section. Once again, this is not legal advice. It is for educational purposes only. It is your responsibility to learn the law and put it to use it to your advantage. If you'd like to learn more, you can go to look in the description box below, click on my link to my website, creditforbadcreditforyou.com. There's a whole lot of other information there. You can learn how to get signed up for a free webinar and get on a weekly telephone call where you hear about hundreds and hundreds of other people who are winning lawsuits against rogue debt collectors, and they're having fun doing it, and they're putting money in their pockets. Go to the website, and we'll see you on the next video. Thanks.